Michael Popok, and it's time for Legal AF After Dark. You know what that means. We're at the end of the Trump trial. 20 witnesses. The jury verdict form and the jury charge conference has been completed, and we're going into closing arguments or summation, and we're going into the jury deliberations. Is there an advantage to the prosecutor? By the way, Judge Merchan has decided that the second crime necessary to prove a felony has to be proven in front of the jury. Is that advantage prosecution or advantage to Donald Trump? Now that Donald Trump has decided not to testify and waive his Fifth Amendment privilege, who better for me to kick it around with than my colleague on Midweek, Karen Friedman Agnifilo? Let's take a listen. Let's talk about Trump on trial. So, jury charge conference going on. To me, it looks like the prosecution's doing great. There's one in particular I want to kick off with, which is the second crime issue, because this looks like a big win for the prosecution, and I want to get your opinion about it. So just to keep everybody up to speed, Trump's violating the gag order again, and the judge will have to deal with that. And then during this charge conference, which is to get straight and work it out with the judge, what the actual jury instructions are going to be, the jury charges are going to be before they're charged. And it's really important. You said yesterday, if I recall, during our wrap, or one of them, you said, and I've mentioned it before too, it's one of the biggest grounds for reversible error around, which is to get your jury charges wrong. That's why even when the judge does it and reads them and you've approved them, everybody that's a lawyer that's involved is like reading with a finger along to make sure there isn't a mistake, a comma out of place, a word out of place. And I've been there. I'm sure you have too. When you say, "Oh, judge, you missed a word there. Got to go back. You left out don't or no or whatever." And because it's really important you get that charge right. And so they're battling it over now. And then the second crime issue is, and we've talked about this at length, but I think it deserves another pass here, is that the business record fraud at the heart of the case, which is the entry in the books and records of the Trump Organization of the payment ultimately to Stormy Daniels, which got recorded instead as a payment for legal services rendered to Michael Cohen, who then used it to repay himself for having laid out the money for Donald Trump. This is so the prosecution argument goes. And then it got recorded, and then that got taken as a business deduction, because that was an expense on their books and records instead of being a direct payment for hush money and election interference and all that. That's crime one. And if that's all that we were talking about, frankly, I doubt your old office would have brought crime one, misdemeanor only, in the state of New York, even though there are thousands and thousands of prosecutions of that over the life history of that statute and that provision. And they're not just picking on Trump, but it became really interesting when a second crime, in furtherance of a second crime, was added on, because that ratchets it up to a Class E felony in New York. And the question we always had was, and I'll just run through the checklist. This is like an FAQ, right? 1, does that second crime have to be charged? No. Does it have to be indicted? No. And what does the second charge have to be? And now the judge has solved that problem. Does the jury have to agree what the crime that's being covered up is? And do they have to have not just consensus, but unanimity about the second crime? The answer is no. So, and I want to hear from you how they're going to present this one. So 7, let's say there's 12 jurors. 7 out of the 12 jurors could think it's a cover-up related to tax fraud. And 5 could think it's a cover-up related to election interference. And he's convicted. There does not have to be unanimity. Let's start there. What's your opinion about it, and how do you think that helps or hinders the prosecution or the defense? And what do you tell? I mean, we've been following this closely. What have they been told about tax fraud and or election fraud in Kuwait in order to make that determination as a jury?
So I remember when this case was first brought, this is what the question that everyone's asked. And I'm talking to reporters, other lawyers on TV, et cetera. And everyone is asking this exact crime. How did it back then and still now, as it reminds me of burglary. And I know I've said this before, but I want to say it again, because it turns out this is exactly how the judge is doing it, exactly how I've been describing it all along. where people, really, really smart lawyers, smarter than me actually, were saying, no, it can't be, that can't possibly be the case. And so every once in a while, I actually know something from my experience, because I've been doing this a long time. And so I was very pleased to see that I didn't get that wrong, because it made me concerned, because there are people who thought this isn't possible. But this is exactly how it's always done. And let me explain what it is. That it's a general criminal intent. It's not, I have the intention to go out and I'm going to, the elements of a particular crime, I'm going to make sure that I meet each and every one of those elements. It's a general criminal intent, meaning I'm going to commit a crime. I'm not doing this in a way that is above board, that is legal. I'm hiding it. I am doing everything I can. It's like money laundering almost, right? But this is like you're laundering, this isn't money laundering, but it's similar to that. You're trying to make it look like something that it isn't, so that it can't be traced back to you. And the burglary example is burglary is a trespass misdemeanor, which is you enter or remain unlawfully somewhere. But it becomes a felony, burglary. It's just a misdemeanor trespass plus. And the plus is the intention to commit a crime therein. And that's what I have experience prosecuting. I've prosecuted hundreds, if not thousands, of burglaries on the course of my career. When you never specify what the crime therein is, because you don't really know half the time, right? Sometimes they get caught in the act before they've done anything. Sometimes you do know what the crime is. It's, sometimes it's sexual assault, or it's theft, or it's some other thing. And sometimes you can infer criminal intent through surrounding circumstances, because you're not in the brain of the person. And so if they get caught as they walk in the door before they've done anything, you look at the surrounding circumstances to try to figure out what is, what is it that they have the intention to do. And there's another possibility. You have a guy who's a burglar walking up and down a hall, jiggling doorknobs. He doesn't know what crime he's going to commit once he gets in. It depends on what's in there. He just knows he's going to go in there and see, and whatever it is. And if he gets caught the minute he gets steps in the door without having done anything, and without having a specific intent of which crime he's going to commit, he gets charged with burglary too, because he was going to commit a crime therein. And so there is no difference between that kind of intent and this kind of intent. This is false business records, meaning you have entered, or you have put some sort of entry or omission, or you have caused the entry or omission of false information in the business records of an enterprise, okay, with an unlawful intent. And that is falsification of business records. And the unlawful intent there means you didn't make a mistake, okay? So you intentionally caused false information. You didn't just get it wrong. And that's a misdemeanor crime. And what makes it a felony is if you are in furtherance of another crime, like you're doing this to either cause or aid the commission of some other crime, or to conceal another crime, et cetera. And so here, that is what the jury is going to be charged in, this general criminal intent. Now, the prosecution is going to argue on summation that this other crime is going to be election violations, because donating all this money that this $420,000 that they structured over 12 months to reimburse Michael Cohen for legal fees. It was a reimbursement, not legal fees. The reimbursement, but they called it legal fees. That's why it was false. The reason they structured it like that was it wasn't a reimbursement. This was in order to not have to claim this $130,000 payment to Stormy Daniels. They didn't have to claim it in to the Federal Election Commission, which they would normally have to do, because it's an in-kind campaign donation. And so that's going to be, it could be federal, state, and the other is the tax crime, income tax. They made it look like income tax so that even though it wasn't income to Michael Cohen, so that he would be made whole, plus he'd get a bonus in order to get paid back. So that's how they did it. The jury charge, the judge is doing it exactly how I know this to be, how we do it in New York, and how it's done in every other case. So I guess it's a win for the prosecution, in the sense that the judge is doing following the law and giving them what it should be. But that was sort of the main decision in the jury charge conference, that the judge is going to be charging the jury next week.
Yeah, the reason I see it as, even though they're following the law, the reason I see it as a win is because if he had done the alternative, which would have been against the law, and forced there to be a unanimous decision on either election interference or tax fraud, that would have also, as you mentioned, would have basically turned the law on its head about what the general intent was, and it gives this way the jury has a little bit of a Chinese menu, a little bit of a column A and column B, and the jurors don't have to, and they'll have to be instructed about that. They can't just be left to their own devices. They'll have to be told, when you go back, it's okay, because they can't be left under the impression that we've got to figure out the second crime, because that'll just, A, it's wrong, and B, it'll waste a lot of time. They have to be told in the instruction, you don't have to reach a unanimous decision, just that there was a second crime, and you can fill in the blank about what you think that second crime was based on the evidence. I mean, it has to adhere to the evidence, and all of that. So I like that. What'd you think about Emile Beauvais' attempt once again to have some sort of advice of counsel or presence of counsel? And the argument there is, well, Donald Trump just entered into these NDAs, these non-disclosure agreements, and these arrangements with Karen McDougal and with Stormy Daniels, because lawyers told him to do it, And Emile said, well, yeah, David Pecker testified, Your Honor. He said that David Pecker said that the arrangement with Karen McDougal was bulletproof, and that implied lawyers were involved. Judge, let us instruct the jury about that. Why don't you tell the audience about what is a advice or presence of counsel as an instruction, what it would do for the defense if they were getting it, and then of course they're not getting it.
Yeah. So an advice of counsel, first of all, what Salty's putting up, this graphic shows, the judge was not happy that Emile Beauvais raised this again. This has been litigated before. A judge says, I've litigated this before, I'm not changing my mind. But Emile Beauvais, I think, was trying to he was trying to preserve the record, because look, the jury charge is one of the number one ways that a case gets reversed. So the jury charge, you have to get it right. You have to preserve things. And because that would just, what good is a conviction if it gets reversed, right? So, what the advice of counsel is, what that defense is, it's like an affirmative defense, and basically what it is it says, if you give your lawyer all the information they need to give you advice, and they give you advice, and it turns out they were wrong, and you relied on that advice in good faith, you can assert that, but you end up committing a crime incidentally. You can say, look, I relied on my lawyer for this advice. It was all done in good faith. We just got it wrong. That would be an affirmative defense. Now, what it does is, if you assert this affirmative defense, meaning you now have the burden to prove this defense by the preponderance of the evidence, which is a lower standard than beyond a reasonable doubt, which is what the prosecution has to do. What happens is it will then trigger a waiver of the attorney-client privilege between you and that lawyer, the one that you have the advice of counsel with. That lawyer can't represent you because there'll be a witness at the trial. And the prosecution then gets access to all communications, notes, et cetera, that you normally wouldn't get between the client and the attorney, because the advice of counsel defense will waive that privilege. And since they didn't assert it in time here, they didn't waive the privilege. And when they finally tried to do it and they litigated it, correct me if I'm wrong, I believe the judge found not that it just wasn't timely, but that it just wasn't appropriate here. And the judge then ruled there is no advice of counsel defense here, so you can't argue that, and I'm not going to charge the jury of that.
And what facts were developed during the trial? That this is the thing. You can't just have sort of free-floating jury instructions that don't match the facts that are before, because that's worse, right? Then you got a jury who's, talk about idle hands or a devil's plaything. Jury instructions that don't match facts are deadly. Oh, that's interesting. Let's use that. But there weren't a fact developed by a witness. So it's okay. I like that particular. I like Trump. Let's use that. So what am I wrong? Were there any facts? There couldn't have
No,
been because the judge didn't allow the defense.
correct.
So I get that Emile Bove, but the judge was like, you were late, and I denied
Well,
it.
I think
I
what-
denied
I
it
think-
anyway.
Well, I think what they would say, I guess the facts they would argue, I'm trying to put myself
Are
in their
already in
shoes.
evidence.
They'll say, look, Michael Cohen was my personal lawyer. I was relying on him to tell me how to do this. So, I mean, I
Yeah.
suppose.
Yeah, except some of the reporting is they were focused on Pecker saying bulletproof, but maybe they
Yeah,
were relying
exactly.
on Michael. You know, this has always been a weird case
Yeah.
for conservative traditional lawyers like you and me and Ben, because you had, some people were saying, like, in the chat the other day when you and I were doing it, like, how can you have Bob Costello testify against Michael Cohen when he was his lawyer, or at least Michael Cohen thought he was his lawyer, or he thought he was his lawyer? Like, where is the privilege? So many of Trump's cases are about stripping privilege away and people testifying over it. I don't want people to come away with the impression that this is normal. I mean, I've been doing this for 32 years. I've never had the privilege stripped away from me. And I know that it is, for me, sacrosanct and ironclad. And I'm very careful about preserving the privilege that's held by the client. But here, in the cases involving Trump, Evan Corcoran stripped of, Donald Trump stripped of the attorney-client privilege with Evan Corcoran, crime fraud accession. Michael Cohen, Bob Costello testifying about his client, Michael Cohen. It make people think they shouldn't go talk to lawyers confidentially because they'll end up, in some sort of criminal case.
Such a good point. It really is so abnormal and so strange. And everything that they do is so abnormal. Even being held in contempt 10 times. I've never had a situation where anyone was held in contempt in any one of my cases as a prosecutor or a defense attorney. I only know of one case that I was supervising where there was a contempt proceeding. That's it. I mean, most judges have never even done that. And yet here, 10 different times he was held in contempt in a criminal case. I mean, it's just shocking. A gag order, same thing. There aren't that many gag orders imposed in many cases. You don't have threats to witnesses or to prosecutors or to prosecutors' families or, all that kind of stuff. Same thing with asking for a recusal motion for a judge. I don't think I've ever asked for that.
Let me ask you something. I'm just thinking about this out loud. One of Donald Trump's goals has been to undermine one of our pillars of our society. Well, two, right? The government.
I think all of them. All of them.
You're right. The government, the prosecutors, the investigators, the court system, destabilize them,
Yes.
devalue them, right? Leave Karen back up. Someone ask her something. Devalue them.
It's okay. I was just shifting it. I was shifting in my seat, and Salty didn't want to.
Oh, I'm sorry. I was
to-
getting vertigo from how many times we were cutting away from Karen. Okay. Here's the question. Why won't others who aren't named Donald Trump now think it's appropriate, lawyers too, to yell at their judges, to act with a lack of decorum and respect for the system, to attack their prosecutors, bless you, and witnesses and their families? Why won't there, or do you think there will be more acting out now in courts that courts have to worry about with all the rhetoric for Donald Trump? Or do you think this is an anomalous outlier, sui generis because it's Donald Trump?
I have to say I've noticed a general lack of civility and decorum that Donald Trump has brought forth. There are people who will speak online, for example, in ways that I don't think they would ever normally speak. You saw in Congress today or yesterday, Marjorie Taylor Greene and another representative, I think her last name is Crockett, got into, just a screaming match and shouting match where their AOC had to jump in and there's like name calling and just really, really unprofessional. And same thing with the Mar-a-Lago case that we're going to talk about in a little while. There was shouting in court. I mean, it's just not the way we've been raised, if you will, just as a civil society, just the way Trump talks, the way Trump threatens people, the way Trump, calls everybody names. Everybody has some derogatory nickname, and somehow it's almost like it gives permission for people to behave a certain way in all areas. It's not just in court, but I think the president, he is a leader. You set the tone. You, it's like any organization, the leader sets the tone, right? Of what's acceptable, what's not acceptable, what the culture will be, et cetera. And Donald Trump has definitely, I think, really changed our society in a way that is not for the better. And it's certainly not a good thing. And I think, I hope it doesn't bleed into the court system beyond him.
I think I agree with you. I think that social contract has been torn and thrown into tatters at our feet. And it has given license and permission to people to act inappropriately, to be at each other, to be at our neighbors' throats, if you will. And I think it is bleeding over and crossing over into the court system. And I think the courts, if they haven't already scheduled judge camp and court personnel camp on how to handle it, it's sort of like in the airlines. What the airlines have been seeing post-COVID in the amount of abuse and violence that's happening on the aircrafts, the way that had never been before COVID. They've had to retrain their personnel about how to deal with it. And it's not that toothpaste isn't going back into the tube. I don't think this is going back in the tube. And the federal courts are going to have a strong hand here in the future, as people are going to actually think, well, Trump did it. I mean, like you said, tone from the top. That seems okay. Well, we're going to talk about more screaming that happened. Welcome back. That was Legal AF. You may already know that. And if you do, thank you for being part of our audience. We really appreciate you. If you don't know what I'm talking about, that's a little show we like to call Legal AF for a reason. If you don't know why, join us on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this MeidasTouch YouTube channel, and you too will know why. We call it Legal AF. You can get it on our YouTube channel, and then you can get it on all of our platforms related to audio podcasts. If you know all about us, again, thank you. If you don't know about us, this is an invitation for you to join our audience. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.